Johnny Depp trial, Amber Heard suddenly demands the case to be dismissed.
As is the case here, has failed to present evidence sufficient to create an issue of fact on his claims. And in addition, the court may not draw inferences from the evidence that defy logic and common sense. That's the Austin versus Shoney's case, 254 Virginia 134. So the issue here, Your Honor, is a couplefold, and I'll take the statements.
Is he trying to say that Johnny Depp? Wait.
Well, two of them in one category and one of them in the other category. But I think we're all clear that the sole issue here is whether Amber Heard can be held liable to Mr. Depp for defamation arising from the 2018 op-ed and the 2018 op-ed alone. And to establish that, Mr. Depp has to prove the following elements. He has to prove that the publication of the op-ed and that it was written by Ms. Heard.
Yeah, defamation is really hard to win. I think you have to show intention or something. It's like really difficult to win. But I don't think it matters. I don't think that matters because he wins anyway. You know what I mean? Like, she loses, her career is now over. He wins, he's going to be able to get his career back. So even if he doesn't win in court, like, he wins in the court of public opinion.
He has to prove that the statements in the op-ed were both false and defamatory. So falsity, and that they contained a sufficient defamatory sting, and he has to show that the statements were made with the requisite intent. In this case,
well, didn't they show clips of her like lying, like saying that she was like lying about it, like
actual malice on the part of Amber.
I gotta get somebody, when somebody makes like a full recap of the whole thing, I'm gonna definitely be all over that.
Heard. I'll save that argument till the end, Your Honor, and I'll focus on the first two at this point. And because it seems like plaintiff is proceeding under a theory of defamation by implication, under the Pendleton case, 290 Virginia 162, plaintiff bears the burden of proving that the statements.
Oh no, Johnny Depp was the one who. Wait, who posed the lawsuit? Was it Johnny Depp, right? It was Johnny Depp suing Amber Heard for defamation. Yeah, I think I'm having a brain fart. It's like fucking 4 a.m.
Were designed and intended.
Can he get his career back? Probably. Yeah.
By Ms. Heard to imply a defamatory meaning. Designed and intended to imply defamatory meaning. So, and to satisfy those first two elements, publication and falsity and defamation or defamatory nature of the statements, Mr. Depp bears the burden of proving that by a preponderance of the evidence, and to satisfy the requisite intent and show that Ms. Heard acted with actual malice, he has a heightened standard of proof that he must prove by clear and convincing evidence that Ms. Heard acted with that malice. Okay. So just want to talk about.
Oh shit. Okay, now it really just clicked. Sorry, I have a brain fart. So he's doing this, or she's doing this because she's about to go on trial, yeah? So this is before she goes on. She already knows she looks like fucking horrible dog shit. And so it's like, hey, let's just dismiss the case and move on. Honestly, she'd be better to just take the L and be like, I lose the lawsuit. I'll fucking pay whatever. What is he suing for? How much is he suing for? That's the question I'm wondering.
About the two statements on domestic abuse in the op-ed. And Your Honor's well aware of the ample Virginia case laws talking about how you have to view the op-ed as a whole. You have to view words in context. So these are the statements that read, then 2 years ago, I became a public figure representing domestic abuse. And then the other statement that says, I had the rare advantage.
All right, so he's suing her for $50 million. Okay. Over an article in the Washington Post from 2018, which she describes herself as a public figure repressing domestic abuse. Okay, and then she's countersuing him for $100 million, claiming that Depp defamed her with his legal team referred to her claim as fake and a sexual violence. What it is, that's what it seems like. Okay, hold on a second. Okay, I'm curious. What is her net worth? What is his? Okay. Hold on. I'll look into that as I do this.
Point of seeing in real time how institutions protect men accused of abuse. Now, those statements are entirely opinion, except.
Wait, her net worth, from what I'm seeing, is $2.5 million. And I think net worth is like the collection of all of your assets and whatnot. And like, but if he's suing her for $50 million, oh, she's so fucked. So I'm gonna be honest with you. I'm guaranteeing that she's not gonna win. I don't think that she's going to win. I don't think he's going to win because it's probably be very difficult to prove the defamation. So he's probably not going to win the court case because the judge probably not going to it's not going to happen. I guarantee it. So, but this is the problem though for her is that they're moving to dismiss. She can't just concede. She can't concede to this. It's a jury though. I doubt it. The jury's not looking at TikTok. That's the thing. So like the jury, this is what you guys don't understand is like the jury is sitting here and they are like, I guess, deliberating on the information that they're getting now. They're not watching TikTok. They're not watching YouTube. They don't have the court. They're not part of like that atmosphere of public opinion. So if there is a jury, they're not like going to be influenced by anything. You know, so I'm pretty sure she's gonna lose. She's not gonna lose. It's gonna be probably dismissed at some point, but not until it's over. So her thing is like she can't just say, "Hey, I did it," and move on. That would be the best for her, because then maybe she can recover from it. Probably not, but so she has to either get it dismissed or she has to move forward, because she can't just like take the L, because she can't afford it. She can't afford it. It's fucking crazy.
It's
funny.
According to Mr. Depp,
what a piece of shit bitch.
The discussion of domestic abuse. So the statement, "I became a public figure representing domestic abuse," and the statement in the second sentence that Mr. Depp was a man accused of abuse. The rest of those are inactionable opinion statements. Now the evidence.
Yeah, I'm pretty sure the jury would be put in like in special housing. This is how this kind of shit works all the time. Yeah.
Adduced thus far, Your Honor, shows that Mr. Depp can't sustain a claim on these for two reasons. First of all, the statements are true on their face. I don't think that there's any dispute about that, and that's been the subject of some testimony in this case. 2 years before she wrote the op-ed, Ms. Heard did, in fact, become a public figure representing domestic abuse when she obtained a domestic violence restraining order against Mr. Depp, and Mr. Depp was indeed accused of abuse. Those are facts that are true. Now, to the extent that Mr. Depp will argue that he's proceeding on a defamation by implication claim, again, the court should grant the motion to strike because the undisputed evidence is that he did, in fact, abuse Amber. Now, there's a dispute.
What?
And the court should grant the motion to strike because the undisputed evidence is that he did, in fact, abuse Amber.
Well, I don't think that's clear at all. I mean, like, there seem to be instances where he was like shitty to her. Absolutely. But she was far worse to him. And like, yeah, you could definitely claim, people were calling it reactionary abuse. That makes perfect sense. It's interesting that he's just saying like, yeah, this is an objective truth. So even if this, from what it sounds like to me, I don't even know if they actually think that they can get dismissed. I think it's more about being able to, I don't know, because it's weird. Like, I guess you can't object during this. I don't really know how the law works, but he's making these absolute statements that are just wrong. Like, there's objective proof that he abused her, or it's not even saying that there's proof. He's saying that it is like he's saying that he abused her, right?
Should grant the motion to strike because defamation by implication claim is that he did, in fact, abuse Amber.
Yeah, he's saying that he abused her, which is just like not true based on what we've seen. But now he gets to say why if there's objections, why is nobody objecting to what this dude's saying right now? You know what I mean? It just sounds like he's using this as a time to be able to sway the jury by just saying, like, making absolute false statements.
Now, there's a dispute in this case. There's ample evidence that he physically abused Amber, but we acknowwise that there's a dispute in this case on that.
Yeah, it sounds like a closing statement, yeah.
There isn't a dispute in this case is non-physical abuse. Both Mr. Depp and his expert Shannon Curry.
Wait.
There isn't a dispute in this case is non-physical abuse. Both Mr. Depp and his expert Shannon Curry have testified that abuse may come in many forms. It may be physical, certainly, but it may also be verbal, maybe emotional, maybe psychological. You'll recall Mr. Depp even kind of setting the baseline for what abuse was when he talked about the non-physical abuse that he allegedly suffered at the hands of his mother. He said it was worse than the beatings. And the example he gave was that his mom
how fucked up is that, dude? Like, I understand it's a court of law and this lawyer's doing his job, but what a scumbag. Like, holy fuck. He's like, yeah, remember when you told us that your mom beating you wasn't as bad as when she would verbally berate you? Yeah, remember that, Johnny Depp, you fucking asshole who abused a girl? And by the way, I'm guaranteeing you that they're trying to make the comparison between Johnny Depp being abused by his mother and Johnny Depp being an abuser, because a lot of times, like, people who are abused, they repeat the patterns of their parent. And so it seems like that's part of, that seems to be like the subtextual argument that's being made here.
Used to call him One Eye as an example, because he had a lazy eye, I guess, as a child. That was something that Mr. Depp himself said was abuse. His mom calling him One Eye. So we're setting aside the evidence of physical abuse in this case, which is already overwhelming.
Calling him One Eye isn't abusive. It's the way in which she did it. But I this is very interesting wording, because what he's trying to do is say, like, bro, how fucking crazy is that? He's removing all the nuance from, apparently Johnny Depp mentioned that, like, his mom would call him One Eye. After, I guess, abusing him so much that, like, he became, had one eye. And the nuance there would be, like, there's probably a pattern of her berating the fuck out of him and treating him like total garbage and just completely destroying him. And as a kid, your parents are your whole world. And, like, even when you become an adult, they're massive influencers, but massive influence on your perspective in your world. So he's saying this but he's watering it down to like, she was just saying that you had a weird eye. And then, since what he's trying to do is saying, since you think that it's abusive to just make fun of someone's eye, then the way that you were treating Amber Heard must be abusive. Because, like, hey, oh, you have one eye? It'd be like the same as, like, oh, I guess then calling someone 4 eyes is abusive, or not giving them toilet paper when they're shitting and then running out of toilet paper. You know what I mean? Like, so it's so interesting and really fucked up.
Mr. Depp's claims relating to these 2 statements should be stricken because of the ample and undisputed evidence in the record of non-physical abuse by Mr. Depp toward Ms. Heard. There's evidence in the record of recordings, messages, including messages written in blood with his finger, blood and paint, vile names.
Blood and paint? Wait, what does that mean?
Messages, including messages written in blood with his finger, blood and paint.
Okay, well, if it's blood and paint, I don't know the context. It sounds like you're exaggerating.
Vile names, shouting.
I'm sure we're going to get a nice big old fucking rundown video from somebody. Maybe John Swan can come back and give us one.
Menacing and threatening statements. There's the video, the kitchen video in Sweetser. There's the audio of him calling Miss Heard, like I say, numerous vile names. There's the audio of him asking to
say it, pussy,
to her to cut him, and whether she wanted to be cut. So there's plenty of evidence out of the words or out of the mouth of the plaintiff in this case that constitutes non-physical abuse of Miss Heard. Again, under the standards set forth by his expert.
See, the standards set forth by his expert. Oh, he's such a scumbag. Holy fuck.
And the plaintiff himself. Those are far worse than his mother calling him one eye when he was a child.
See, they're downplaying that. Like, I doubt it was just one eye. It was probably like a consistent pattern of like being fucking shitty.
In addition to that, Your Honor, there's Travis McGivern's testimony from yesterday in which he testified that at a minimum on the night of March 23rd, 2015, both parties were being verbally abusive to each other.
Probably.
Mr. McGivern also testified.
But that's how toxic relationships work, bro. Like, I've been in toxic relationships that were not abusive. Like, you're shitty to each other, like really shitty. And it's because you guys shouldn't be together. This doesn't seem like that, though. Right? This is like, you know, and of course in those relationships there's even somebody who's shittier. And like, you know, for my relationship, my ex was shittier than me. But like, I still wouldn't consider it fucking abuse because I'm not like an insane psychopath. But like, this is where it seems like she abuses the shit out of this guy. And then he's like having a reaction of being like shitty as well. Sure, but not to the same degree.
About Mr. Depp, quote, rearranging her closet, throwing racks of clothing down onto the floor and throwing at least one rack down the stairs. Now, in California, property damage alone can be a basis for getting a temporary restraining order under California law. So further evidence of non-physical abuse or non-physical toward Ms. Heard. You saw the cupboards in the Sweetser kitchen video. And then Dr. Laurel Anderson, Your Honor, testified that she believed that the parties engaged in mutual abuse and that at least some of the time that was initiated by Mr. Depp. This is all evidence. We haven't gotten to put on our case yet. And to the extent this case proceeds, and that will start now. But this is all evidence that has come in while plaintiff controls the playing field of what evidence has come in, and he can't overcome that. In this case, Your Honor, if Mr. Depp abused Ms. Heard physically, verbally, emotionally, or psychologically even one time,
it's equal. I don't agree with that. I know you're saying do more. I've watched a decent amount of this. Like, I've seen enough of like the shitty things, and I remember making my video, and I came into it very objective. And I was like, okay, like they are both being what I would consider like, I guess, abusive to each other. Like he would get drunk and like yell and break stuff. And then she would also get like drunk or on some substance. And then she would hit him. That's not equal abuse. I know. Okay. What is that? What is that? Bro. What is you saying it's a defamation case, not a defamation, like a domestic violence case, have to do with anything that I'm saying right now? It sounds like you're just throwing out talking points that you heard on the internet. That's not to be rude. And then you saying that there's a 20-year age difference. Why does that matter? Why does that make a difference? Calm down. We can discuss this. Okay. I understand power dynamics probably better than you do. But just because there's an existence of a power dynamic doesn't mean that there's instant abuse of the dynamic. So just because he's older, you have to show how that has had an impact in a way where he's weaponized that age, which you're not going to be able to show that at all. She was, from what I've seen, much worse than him. So yeah, she's shitty, or probably more of the reason why he was so shitty to her, because of the environment that was created of like high tension and toxicity. But yeah,
then she wins on those claims. Then she wins. It's that simple. And the evidence is overwhelming and undisputed in the ways that I've just described.
She was 25 and he's 45. Not a biggie, but it's something to consider. What's to consider though? Because I feel like we're getting into like this new age conversation of like different age differences, whatever. And I get it. And it's weird. Listen, when I'm 45, I don't think I would date a 25-year-old. Hopefully I don't. But it doesn't mean anything. Like, it doesn't matter. And she's even at 25, so she's beyond the point of like mental development. Like that's when you usually finish developing mentally. So there's nothing even really there
that he did. So for
I know you're saying that you're trying to show both sides, but like you have to understand like some of your information is kind of like it's just bizarre. Like the 20-year age gap is so irrelevant. So like I understand what you're saying because to you it's like, okay, if I weigh this in my brain, I look at a 20-year age difference, and if that's a bad thing, that's something that weighs against him. But if we can establish it's not a bad thing and it really doesn't matter, then it's no longer something that we could use against Johnny Depp. So I would say like that's an illegitimate claim. It doesn't really matter. You know, if he was 35, there was a 20-year age difference, then I would be like, yes, that's fucking very problematic. But it's kind of inconsequential. It doesn't really matter. It's kind of an irrelevance thing to the case. And so like I would just be careful about that because we're getting into weird conversations about like age of consent, which makes perfect sense. But with that, sometimes we like to tie, like for instance, people call Keemstar like a fucking abuser and a predator, because he talks to like 21-year-old girls. Who gives a shit? It really doesn't matter. It doesn't mean anything. You know what I mean? He's not any of those things, and it's actually insulting to people who are actually abused and predatorized to consider that relationship that So
for that reason, Your Honor,
my parents are 20 years apart. My husband is 12 years older now. It's more like, what do you expect when you date one 20 years younger? What do you mean? What do you expect? Like, do you expect to get hit if you date a woman 20 years younger? That's what you're kind of saying is like, yeah, if you date a girl that's really like a lot younger than you expect to get beat and like attacked. Is that what you're trying to say?
those claims should be stricken. And I'll just cite the Union of Needle Trades versus Jones case. This is 268 Virginia 512 that states if the plaintiff does not establish the falsity of the statement by a preponderance of the evidence in his case in chief, he has not met his threshold burden, and the trial court should strike the evidence and grant summary judgment to the defendant. That's exactly what should happen here. Now I'll move on to the second issue, which is the headline containing the phrase sexual violence. That should be stricken for a couple reasons. First, Your Honor, the evidence has established that Ms. Heard didn't write the headline. Mr. Doherty from the ACLU, that's the only evidence that's come in this case thus far. Plaintiffs control the evidence.
Well, I understand, but there's also a stipulation that Ms. Heard would not be called in the plaintiff's case because they would then use her testimony for part of their case in your case, right?
That's correct, Your Honor.
Yeah, I agree, and that goes to a different issue that I'm not arguing. I'm not arguing that the court should strike because they haven't put Ms. Heard on to testify about the headline.
But I assume part of that would be that they would, I guess they intend to get from Ms. Heard is that she either wrote it or republished it.
Yeah, what happened the next day is Ms. Heard posted it on her Instagram account and said, "Look what I published yesterday."
Oh, I see what she's saying. It took me a second. I'm old. So what she's saying is like, okay, you're proposing information after you've examined, you've been able to press Johnny Depp on everything. We haven't been able to press Amber Heard on anything yet, so we don't know what the response is going to be. So it's like one of those things where they get to basically rewrite history and like pose really I guess you call them leading questions or incorrect questions or like probably very leading questions so that they get specific answers to Johnny Depp and go, look, he's a bad guy. Everything he's saying is bullshit. Let's move on, before his lawyers do the exact same thing to Amber Heard, right? I'm just like, there's something to consider. I'm saying it's not something to really consider because what you effectively said is like, hey, what do you expect when you date a younger girl? I don't think that you ever expect to get like abused. I feel like that's kind of like a dishonest. Like if you said to me, oh, I dated a girl that was 25 and I'm like fucking 45 and she was really immature and like was shitty. And you said, what do you expect? I'd be like, yeah, okay, she's immature and shitty. Maybe she fucking shits on the bed or she goes out partying a lot. But when you say like abuse, well, that's abuse, when drama. Yeah, but I just don't think that you can call this drama. Like drama is not, this isn't Euphoria. You know what I mean? Where drama is like super insane. Drama for most people is like, oh my God, she's talking to other guys, not like, oh my God, she's like beating me and throwing bottles at me and I'm trying to run away from her,
Washington Post. So she adopted the title and her name.
Also, you generally expect like the older person to be the more abusive person because like that's the only thing that you would be able to consider in an older age dynamic is the fact that like, okay, this older person like is more mature, so they can kind of like almost manipulate the younger person possibly. They're both consenting adults, so it doesn't matter, but we're not seeing that here. So like that doesn't even make sense. She has the control over Johnny Depp. That's what everything that we've seen seems so far.
Was on the article which contained the title.
And Mr. Ronborn, the only reason I'm sorry to interrupt you, only because I know that was a stipulation, so it's hard for me to say that that's all the evidence for motion to strike if there's a stipulation that they're still going to get more evidence in on that particular issue.
I think
it's difficult to explain. I understand what you're saying. I think that the reason it's difficult to explain is because like I think you should really try to consider it more. Like sit back and like think about it for a little bit. What I'm saying to you, because I don't think that you have like a defensible point so much. I think like, you know, I'm not trying to be rude. I don't think you have like a super defensible point. I'm not understanding you because you're not really communicating well. And I think that either maybe you're just horrible at communicating, or maybe you don't have a point and you kind of like latched onto an idea and you're pushing it because it makes fundamental sense to you, but it doesn't make sense when you apply it to this.
And I'm happy to hand the court the transcript of the April 8th hearing, because one of the things that we're not arguing today is that because they haven't put in evidence of I think it was a tweet, but Mr. Chu says it was Instagram, I don't know, whatever it was, that because there was...
It was a tweet adopting the op-ed she published the day before in the Washington Post.
Okay.
All right. So what I'm not arguing today is that because they haven't gotten that tweet into evidence or had Ms. Heard say that she tweeted that we're entitled to summary judgment at this point. I'm not arguing that, but that's all that we discussed on April 8th, and I'm happy to hand the transcript up, Your Honor. And we actually it wasn't a stipulation. It was simply an agreement that they didn't need to call her in their case in chief to make that point. And then Ms. Bredehoft said we'd have to agree on the language of any stipulation. They haven't proposed anything to us and haven't gotten back to us. So I think that that's only relevant. We're not basing our request for motion to strike here on Ms. Heard not having testified to sending that tweet.
But you're saying for the motion to strike, the only evidence before the court is that the Washington Post wrote that title.
Correct. And that's very different from what happened the next day. There's the stipulation.
Right, but if you're signal boosting it, like let's say that I sit down and do an interview, and in that interview, I talk about fucking who do we want to talk about? Who do we want to talk shit about? Okay, I talk shit about Nicholas DeOrio. No, we sit down and they recant our minor drama on Twitter where he's like, "Oh, you did a bad thing with this title," because I just like copied the title. I forgot to put I usually will put somebody's title in there and then put who the video's from as like a direct credit. I forgot to put the person's name in there, and then he called me out, and I was like, "Oh, well, I forgot. It stinks." And I just changed it. Let's say they asked me about that, and I was like, "Yeah, it was like a misconception. You know, it was kind of weird. Maybe he seems biased against me, because he even said that himself." And then after that, they post an article that says like fucking Papa Gut says Nicholas DeOrio is biased and unreliable. And I fucking took that and I put it up and I was like, look at this article. Or I signal boosted it. I think there's a reasonable, you could argue, and I don't know how they're going to do it, but you could argue that I'm just like signal boosting an article I'm in. But also a lot of the subtext there is that like I support the article in some capacity, unless I expressly say like, I don't agree with the title of the article, but it's a good article. You know what I mean? Something like that.
Didn't go toward who wrote the title. That was never part of anything, and it's undisputed. And Ms. Heard will testify that she didn't write the title.
Well, I understand that, but I think
it's not undisputed, Your Honor. I apologize for interrupting.
Okay. But I think the issue is whether it was republication.
Well, and I'll get to that next.
I know, but the problem is, how do I do a motion to strike when that evidence isn't before me yet?
Well, the republication isn't. So the evidence that's before you is that the Washington Post wrote the headline, or that Ms. Heard didn't. And that's the only evidence, and that's not going to change. The tweet, which was the only subject of the discussion of the pre-trial
this lawyer's trying so hard.
There was no stipulation. It was just an agreement that we're not going to base a motion to strike on them not introducing evidence of the tweet. That was what it was. I'm happy to hand the transcript up if Your Honor would like to see that. But that
I love that. He's like, I'm happy to show you the evidence now. It's like, well, no, motherfucker. Like that's supposed to be like the whole whatever, how many ever days or weeks we have left. This is supposed to be Amber Heard's time to get fucking grilled.
Well, because under the Lakova versus Halper case, 995 F3rd 134, retweeting a link doesn't constitute republication. Now that case
dealt it does if you add something to it, but I just don't know the evidence.
Your Honor, very quickly, it's a judicial admission. They admitted in Ms. Heard's answer, she admitted to the tweet. So that establishes that she adopted the op-ed in its entirety, and it was discussed. We talked about judicial admissions. One was the op-ed itself. The second, and this is reflected.
Your Honor, if I could finish my argument. I mean,
see, this is the whole point, bro. I don't think I think he's trying for this to like try to get it going, to get it out of here. I think he's trying, but I think more than anything else, he's looking for an uninterrupted closing statement to reframe people's thoughts now before moving on. Because it has to be like a fucking shot in the dark. And obviously he's trying his hardest to make it work, but I don't think he thinks it's going to work. I think he's using it more as a way to influence the jury's position on particular matters before we even like get there.
I would appreciate it.
I can't wait to oppose this.
That's fine. Go ahead. Go ahead.
So, and again, we can look at the transcript.
You understand my concern.
I do understand your concern, and I guess what I'm saying is that
he does, but he's being fucking slimy about it.
One is there's no dispute, and there's not going to be a dispute that she did not write the headline. So then you look at is the tweet actionable, and the argument here is that as a matter of law, retweeting something isn't actionable. And so, as under the Lakova case, 995 F3rd 134, in that case dealt with hyperlinks and how those aren't actionable. But to be very clear, nothing that was discussed on April 8th, nothing that was discussed at that pretrial conference was in any way relating to any stipulation about who wrote the headline. It was simply that they need not call Ms. Heard in their case in chief to get her to say that she sent a certain tweet. And that tweet's not in evidence yet, but I assume that they'll try to put it in evidence at some point. But that's the tweet doesn't need to be in evidence for you to strike this claim on that basis. So even assuming that the headline implies certain conduct by Mr. Depp, again, Mr. Depp can't meet his burden of proof on this. Third, Your Honor, he can't prove that Ms. Heard acted with actual malice. Mr. Depp hasn't introduced evidence sufficient.
It's really old computers. How are you going to play World of Warcraft on that? Well, we actually probably could.
To permit him to meet this. Now, again,
yeah, 1995 with the hyperlink thing. Is that what it's from? I missed that, but that's actually a really good point because like 1995, bro, times change in more ways than one. We are really bad as I think all countries probably are, but we're really bad at like policing online interactions. So, for instance, like Amazon was able to like undercut bookstores and like they took a $3 billion loss to like put a ton of bookstores out of business. It's a really predatory tactic, but it's done online, and we haven't really like shaped their online perspective. Things like that have happened a lot. Different copywriting laws, like Napster, and how like that whole fucking thing. It took how long for people to like catch up and stop the selling of illegal music. Just the people's perception, like for all we know, it's just people like dumb and like not understanding hyperlinks or whatever, or not understanding online culture, which people are understanding it now, even older people, because they exist online a lot, especially in like a social media presence for like, politicians, of course. And so, back then, maybe it would have been totally justifiable, but they didn't understand like the online internet landscape. And honestly, even the way in which we engage in like sending images, right? So like, dude, we talk about Carson, but like if a 19-year-old and a 17-year-old exchange nudes, there's no reason for that to be illegal. It's in a lot of places still considered child pornography for the girl to send it, or the guy, the younger person to send it. Like they can get in trouble for it. It's kind of stupid. And to because that like those are totally fine to have sex with of that age. So if it's okay for them to have sex, why does it matter if it's online? Your argument could be like, oh, well, the one person might share those pictures. Okay, but like now you're assuming instant guilt. You know what I mean? I don't think anybody should send images online because they're permanent, but there's so many different things, there's so many different, there's so many different things here, or there's so many different ways in which we are like not caught up at all.
It's a heightened burden of proof. He has to show actual malice by clear and convincing evidence. And as the Bose Corporation case from the U.S. Supreme Court, it talks about the role of judges as gatekeepers of the Constitution, of the First Amendment, and the role of barring entry of a judgment that's not supported by clear and convincing proof. Now, that case was about appellate review of First Amendment issues, but the same holds true for Your Honor here. Here, Mr. Depp hasn't introduced any evidence, and there can't be a reasonable inference drawn that would permit a jury to find that he's proven by clear and convincing evidence that Ms. Heard wrote the words with actual malice. And again, we go back to the testimony of Mr. Doherty, which was their witness. They put him in, and Mr. Doherty, the only evidence relating to intent or anything relating to this op-ed, which was, again, maybe Mr. Chu will try to say that we stipulated to Ms. Heard's intent on April 8th, which of course we didn't. But the only evidence that has been presented in this case, Your Honor, by Mr. Doherty was that the op-ed wasn't Ms. Heard's idea, that the ACLU asked her to write the op-ed, and indeed that they even wrote the first draft, and then that Ms. Heard vetted the finished article with her lawyers and with lawyers from the ACLU to make sure that it wasn't problematic. That is the only evidence in the record. And on that evidence, there cannot be a conclusion that Ms. Heard acted with the actual malice that's necessary, particularly when you consider the heightened burden of proof. So reviewing the op-ed as a whole, with the court acting in its appropriate function as a gatekeeper of the First Amendment, we ask that the court strike plaintiff's evidence and award summary judgment to Ms. Heard, either in whole or in part. Thank you.
All right, thank you. Yes, sir.
Okay.
Good morning, Your Honor. May I please?
That's interesting. I guess they just counter that. I think it was dismissed, so it doesn't matter. But holy shit. Again, I'm pretty sure they're trying to use it as like a closing statement more than anything else. Thank you so much for watching, guys. And another special shout out to all my Patreon and Twitch subs. If you'd like to support this channel further than you already have by just watching the video alone, go down to the links below where you can sub on my Patreon, which will allow you to get your name on this beautiful black wall. Or you can go to the Twitch page and you can actually use a free Amazon Prime sub, if you have Amazon Prime, to subscribe. Thank you very much, guys. Take care.